Welcome to another edition of Legal Titans podcast. This is a program that explores the positive contributions of law to nation building. On this program, we bring legal titans, senior advocates of Nigeria, and some of the brightest minds in the legal profession in Africa to explore the role of law and legal practice in the development of Nigeria. Today, I have my Lene Silk, Adewale Adeshoko SAN, Principal Partner Adeshoko and Co. To explore the role of advocacy and litigation in economic development and nation building. You are welcome, sir.
Thank you. Nice to be here.
I would like you to introduce yourself better and your journey through law.
Thank you, Mr. Fashola. Well, you mentioned my name. My name is Wale Adeshoko. I was called to the bar in 1987. I served in Jos. I stayed back. I worked till December 1989. Then I joined the firm of Chief G.O.K. Ajayi. I worked with him till January 1996. And then I set up Adeshoko and Co. Went for my master's degree in UI in 2002.
Greatest UI, sir.
Yes, I went to Premier University.
Yes.
Then I have gone into alternative dispute resolution. I am a fellow of the Chartered Institute of Arbitration, United Kingdom. I'm a certified mediator. I've been doing advocacy since my call to bar. Actually, that's what I enjoy most. I had opportunity to, very early in my career, to go into the corporate world, join an oil company, but I preferred to be an advocate.
Yes.
And to the glory of God, on September 19, 2016, I was called to the inner bar, and I look back and I give glory to God. It's been a very challenging but rewarding experience.
I can see. Rewarding indeed.
What can you see? Rewarding for me, look, it's not necessarily financial. Don't confuse the rewarding experience with financial reward. Rewarding experience in that, as lawyers, we have so many areas in which we can choose to practice. I see the litigation lawyer, the advocate, as the problem solver, as the real lawyer. He's the one, you're earning money, but you are solving problems for people. If he's alleged to have committed a crime, you are helping to determine whether or not he should go to jail. If he has a contract dispute, you are helping him to solve the problem that people have problems. It is resolution of conflicts, the solution to problems that the lawyer does. So for instance, I take pleasure in the joy that I bring, in the resolution, in the manage of that comes on account of what I do.
Yes.
On account of what I do, which of course fetches me financial reward. But for me, it's just like you see the doctor who is very happy that he's done a complex surgery and has saved the life of somebody. Of course, he gets paid. But for me, it's not just the money. In fact, there's a lot more money to be made in solicitors' practice, transactional lawyers,
even in carpentry or
yes, make a lot of money.
Yes.
But it's important. Part of what I say in the reward of it is that you are solving people's problem. People have disputes. People need to pursue some compensation. People need to ventilate some grievances, and you're able to help them. Of course, they pay you, but it's very, very important. Well, many lawyers are bad managers. If you look at the history of many law firms, you see so much turnover, not even of lawyers, of support staff, because you want to do everything. Things you are not trained for. You went to law school, you went to university to train as a lawyer, not as a man manager, not as an HR person. And we want to fuse everything together. We want to be the accountant. We want to be the HR person. You want to be the one hiring and firing. You want to be the one doing the litigation work. In fact, at a point, some people even think they should be the one typing their processes and so
The
on for
accountant
themselves.
as well.
And become the accountant as well. They even want to go to banks and go and do transactions. So the changes we're having now, people are realizing that, look, no, you cannot be good at everything. In any case, you are not trained to be an effective office administrator. Practice has developed such that don't try to be the accountant. You are not an accountant. Get an accountant. Get a practice administrator, and get people realize the need to break the practice into various divisions. Even in litigation, you cannot be very good in all types of litigation. You need to specialize. Don't try to think you can do everything. And whether you are doing it consciously or unconsciously, people are already recognizing your competencies. And your competencies, there are major areas, there are major briefs you are not likely to have.
Yeah.
There are major areas they are not likely to have. If you are not seen as an expert in aviation, you are not likely to get. When the plane crashes and so on, people know where to go. If you are not seen as an expert in maritime, admiralty practice, people are not likely to come to you for that. Okay, some people have become renowned for election petitions. And for general commercial practice, you find people for constitutional law, So, you have the right to do everything, but you must know your limitations. Don't try to think you can be very, very good in all the areas. No, it's not going. The more lawyers begin to realize that, the better. So they become more focused. They acquire greater competencies in specific areas where they have the skill.
Yeah.
And sometimes it's a function of where you did your apprenticeship.
Yeah.
Sometimes you do it consciously, as people are doing now. For people of our own generation, it's where we did the apprenticeship that conditioned how you developed.
And how you saw the practice.
Well, I guess in those days, advocacy was very, very interesting and appealing, but advocacy is going.
Yeah.
Advocacy is going. Everything is now You file papers, you put them in there, you go to court, the judges even don't want you to talk, they don't want you to adumbrate. If you ask you if you've put it in your brief, if you want to say they will tell you that they will read it. And we are doing less and less of. And that's what many people enjoyed at that time. Oral advocacy.
Yeah.
Unfortunately, is on the way out.
Wow.
Oral advocacy is on the way out. So you have to adapt to changing trends. Changing trend. The number of cases being handled by judges then permitted substantial.
So you have to reach the courtroom.
Yes, the time you can hear 2 appeals in one day and think that you've done work. You won't be able to cope if you are to do. There are more cases to do. Things have grown more cases to do.
And the complexities are even
and so you need to devise means of working faster. The population is increasing. So you're building more courtrooms, appointing more judges, having more work to do. So you need to manage your time a lot better. Unfortunately, you are not the jurisdiction of the superior courts have more or less remained the same.
Yeah.
So they are not restricting the jurisdiction of the superior courts. Supreme Court still has substantially the jurisdiction it had before. So it still has to contend with so many appeals. Whereas they should by now be restricting and constricting the jurisdiction of the superior or of the Supreme Court.
Yes.
Same with the Court of Appeal. And the grounds of leave to appeal is one area. And seen medically as automatic, even when the law says you go for leave to appeal. If you apply within time, invariably they will say right of appeal is constitutional. It's
You're
they
right.
tend to want to grant it, whereas it's supposed to be properly scrutinized to see whether or not it is really, really arguable before you now say, because we are supposed to presume that the court of first instance has done a thorough job.
Yeah.
Maybe the court of first instance should also be doing very thorough jobs, so that once, if a high court in England, a high court judge in England delivers judgment, he will decide whether or not he wants to grant you leave to appeal. So the jurisdiction of the superior courts have remained the same. So you're having a lot more work to do. Population is growing. The economy is expanding, and lawyers are increasing in number.
The issues are even coming up and changing.
Yes, and so
tech is changing and disrupting everything.
And so the facilities for dispensation of justice is not matching the increase.
Growing population.
So one of the ways in which we have tried to adjust is to now reduce the time allotted for that you spend in court giving oral submissions. Okay, file it in. You are no longer just filing it in now. They are now saying that they are even limiting the number of pages that you can write. They don't want to read and read.
History.
They are limiting the number of pages that you can write. They are telling you the kind of fonts you can use, the spacing that you can have, so that they want to spend less time.
Yes.
Even reading what you are putting across. And it's a function of the pressure of work. The number of cases, and the number of judges and the facilities that they have.
But limiting, what I should say, sometimes, how does that, affect the course of justice?
When they limit
number of pages I should write or what I should write.
It is the presumption that a lot of the issues that we raise, they are very clear issues in which the law has become substantially settled, or the resolution of it is easily available. You now have access to easy authorities. In those days, to get law reports, until Ganifa Emi came with Nigerian Weekly Law Reports, it was difficult. Getting law reports wasn't that easy. And you have to wait a long time before they are reported, the ones that are being reported. Now you get your reports, you can research anything anywhere on the net. So you get all your materials very easily with which you can deal with issues, unlike before. And so it is believed that there's nothing you want to say, no submissions you want to make that cannot be easily dealt with. Finding an answer, finding a solution, you can far more easily do your research than before, in which you have to wait. Sometimes judges will say, send your authorities to me, and they don't need to do that anymore. And to cross-check your submissions, to verify your submissions at the touch of buttons now, if you have subscription to legal research methods, now, unlike before, they now have judicial assistants, they now have personal assistants that help them with their researches, and they feel that they can do much more now than before, and that a lot of these matters, most of these matters are matters in which we have bodies of authorities for which they can easily use to take decisions.
While talking, you made reference to apprenticeship. Like, it now depends on where you did your apprenticeship and all that. And it seems like there are less opportunities for people to do apprenticeship these days. That's what a lot of young lawyers talk about, that the room for apprenticeship seems to be reducing on a daily basis, and the welfare of the young lawyers. But I remember that in those days, a lot of now seniors had to go through a lot to learn the rules and the delayed gratification. But today, the culture is different. People want people, I mean, they want their welfare taken care of. Rents in Lagos has ballooned, and everybody is thinking about, my parents are at home, things are hard. How do I give back to them? Do you feel the senior litigation lawyers are against good welfare for young lawyers?
It's not true. Litigation lawyers, most of them are trying. We are operating in an economy. We are operating in an economy, and you can judge how good the economy is. You see, if you say senior litigation lawyers, maybe you are just focusing on senior advocates alone. How many senior advocates do we have in Nigeria? About 800, dead and living. How many law offices are there? There are so many more senior lawyers. So if you think, it's a senior advocate ought to pay so much, senior advocates are just very, very few. What about the other ones? And that's what you think. If you look at, they have overheads, the cost of to run an office. You see, it is important why senior lawyers should not be self-centered and selfish. Junior lawyers need to realize that it is when you get out of law school that you are starting an apprenticeship, especially those who want to do litigation. And an apprentice anywhere, go and check.
They pay to learn.
In fact, in some places, they pay to learn.
Yes.
They pay to learn. What I'm trying to say, the mindset of the apprentice is not comfort. The mindset of the apprentice is not comfort. And so, if new lawyers will have that in mind, it doesn't mean that you should live in abject poverty. But you are saying, you use that phrase, delayed gratification, delayed, if you like, satisfaction and enjoyment. At the time, it is as if you will take anything. You manage anything while you are in the university, while you are in the law school. So they need to see the first few years as a continuation of their training, in which you have to do with a lot of self-denial because you are learning. Because that is where the problem is. They do not think they have to delay their comfort. But my simple reaction is go to anywhere they are doing apprenticeship. You don't start getting comfortable almost immediately. You get something decent enough to make you comfortable, keep your body and soul together when you are learning. When you are learning. And you look at, you need to know that a lot of things go into running a law office. Some of them you can easily take for granted. Forget about hiring an office. What about powering
the office or running the business?
Running the business. The overheads. Buy your computers, your printers, equipping your law library, paying the support staff and the rest of it. By the time you do all of that, how much is left? How much is left? So, maybe seniors need to be, if you like, a bit more generous to their juniors. But for me, more importantly, juniors need to know that the first few years is apprenticeship.
But, if you look at the UK system and where apprenticeship is even institutionalized, what I've seen that happens is that government gets to pay some money to these apprentices, right? Government has like a funding system where, even though you are with employers who are training you, right, there's some subvention that comes. So there's some kind of salary that comes to you, whether through so this training that they do are being paid for somehow, and then they get stipend as well. Shouldn't we look at this kind of system?
Don't compare the two economies. There is social welfare, provision for social welfare over there. We can't compare UK industrialized countries with Nigeria. And you see, unfortunately, we're having a situation in which we're not paying attention to our population growth. We're not paying. They've gotten to the level their population have more or less stabilized. Their populations have stabilized. You don't really have real growth. If America is 350 million 10 years ago, they probably will be around that now. UK, if they were 55 million 10 years ago. But in Nigeria, you can imagine the rate at which we are growing. The rate at which we are growing. So the resources can't go round. The resources can't go round as they used to go before. We have an issue of population that we are not dealing with. An issue of population, how many lawyers are we turning out every year? Is that how many they are turning out in the UK? The resources they have, do we have them? Do we have them here? So we're not paying attention to population growth. We have a choice to say, okay, continue to grow. Well, if they continue to grow, are you matching
that growth
with the resources you are making available? We are opening more and more law faculties. Do we have enough law school, for instance, to take care of them? I won't say we have peaked yet, but we need to keep an eye on our population. We need to keep an eye on our population. You're putting pressure on everything. If you have a population that is highly skilled, no problem. But how many of the newborns actually go to university?
But then I also still want to ask you this particular question about our courtroom system that you spoke about before. I've seen the emergence of disruptive technology, and it's been changing everything. The way people book their taxis now, rather than go to the car park, taxi park to go and book taxi, people now book taxi on their phones.
Yes.
And while they are booking taxi on their phones, they already know the name of the driver, how long it will take them to get to their destination, how much it will cost them, and then they can have the right to say, this taxi driver drove me well, it's pleasant or it's not, right? But still, our own rules in the profession seem static, and also the courtroom practice seems not to have changed, just as you also mentioned earlier. What recommendations do you have in terms of both in the way we as lawyers relate to our clients and also the courtroom system?
First, in relating to our clients, there is no denying we need to leverage on technology. In those days when we were young, we had days in which we asked clients to come for conferences.
Yeah.
They will have to go through traffic sometimes. Some of them travel from nearby towns and villages to come and have meetings with you. Of course, you know that needs to change. You can have virtual meetings. In fact, you have so many clients now that you actually never see face to face, and some you actually meet them in court, maybe when they want to swear to the affidavit or when they want to adopt their written addresses. Now you are doing most of your meetings virtually. Even exchange of documents. When the clients wants to give you documents to use, you're doing them a lot virtually. Even getting them to look through your drafts for comments, especially on affidavits and statements of fact that you've prepared for them. They don't need to see you. So leverage on technology. Apps, necessary apps. Also research, before Nigerian Week Law Reports, you go and buy hard copies and the rest of it. You go and buy hard copies and the rest of it. Colorful books. You know that if you are still doing that system, some people are leaving you behind. You have facilities now, various research platforms on your laptop on the go. To have your legal research. In those days, you go from one library to the other of big law firms to go and use their libraries. You are doing less and less of that, because lawyers need to also subscribe for search engines, research, online research methods to do that. And of course, All those typewriters, electric typewriters, and the rest of it that you use, they have become history. You have to use proper computers, printers, scanners to make your job a lot more efficient. Now the competition is keener, even among lawyers. The competition is keener. Before, some people who are privileged had the resources, they had the authorities, and they can surprise you. Now it's difficult to surprise people on any issue of law. So your research has to be in-depth, and you need to actually be very, very ready before you go to court. In those days, you could get away. You can steal matches, quote unquote, because of the ignorance of your opponent, or because of the information and knowledge edge that you had. That knowledge edge and information edge has closed a lot. So you need to do proper analysis of your case before you get out of, because you are not going to get away because you are going to cite an authority that the man did not know, or the judge did not know. He already knows it. It's out there, and you need to realize now that your authority, that authority you had that 6 months ago, you better go and check it. It may have changed. You better go and check it. It may have changed. Now, going in and out of court. Going in and out of court, things are changing. When do you get to court? How soon do you get to court? We're now having situations in which judges are able to say, come at 10, come at 9, come at... judges are telling you now that you are getting information. SMS, WhatsApp messages, platform that court is not going to sit, court will sit. It's getting a lot better. Unlike before you get to court, before you realize that court is not sitting. That is
your
not...
witness might have even flown
that
in from
isn't,
Canada or anywhere.
That has gone down.
You get to court and they say the judge has
that has gone down drastically. That has gone down drastically. Most courts now give you advance notice whether they're going to sit, either by SMS, by WhatsApp messages. They have various platforms by which they communicate, and it's made things a lot better. Now, talking about judges have more work to do. So I want to imagine that if you have more work to do, it will affect your patience. So go straight to the point. They're in a hurry. If you look at their docket, they have so many. On the list for that day, they have so many. They want to finish quickly. So don't think you have all the time. You need to just go straight and hit the nail on the head in your submission. So in terms of courtroom, government needs to give them the facility. And you see, for me, facility just go beyond giving judges fantastic salaries. What about the work environment? The judge is up there. He needs so many support, technology, and human resources to be able to do his own work effectively. If he wants to work and there is no power, if he wants to work and there is no internet, no internet, no robust internet,
no research facilities. Yes,
if you don't have good printers, you don't have good scanners, you don't have good laptops, you don't have good. So, research assistants, the welfare of the support staff is also very, very important. So we need to, even the environment. There are some courtrooms in Lagos, especially Federal High Court. Happily, they are building a new one, and we've just been eyeing it for years. We just can't wait for it to come on. The courtrooms of the Federal High Court in Lagos is nothing to write home about. So it's bound to affect the general. Sometimes, because the place is so narrow, they stack files on top of one another to search for file. To search for file is another thing.
They're not careful. Documents could even be missing.
Be missing. And if the file is down there or right back there, it discourages the registrar from looking. They don't have spaces. They need to give them ample space. Okay, storage. How do we store? We do a lot of hard copy practice. We need to begin to look at it. You want to file at the court of appeal, they are saying bring 10 copies. You want to file at this court of federal high court, they bring 2 copies. And so at the end of the day, they can't find the copies. All those copies, where do they keep them? People are filing cases upon cases. You must have a storage system, an e-storage system, which allows them to retrieve at the press of a button and to print out if they need to print and certify.
If they need to.
If they need to certify. Maybe you want a CTC or whatever. So, storage system is very, very important. Many times they are looking for... To get... Lagos State has tried to do something. The archives has been substantially modernized and so on. But it's still work in progress. It's still work in progress. All courts need that proper archives system. Now, that's archives. What about for live cases, the cases that you are doing? How do you store those files? How do you store the content of those files so that you can easily retrieve it for the judge to use? The judge is doing a particular case and realize that this issue came up in that other matter. How do I don't know how many.
How can they access information real time?
Real time.
So let me give you an instance. In an American case recently, so one of the lawyers went on ChatGPT, one of the new revolutionary apps, and then he typed and he used ChatGPT to prepare, his case. And then he filed in court and all that. Unfortunately for him, he didn't cross-check. All the authorities were totally false.
I think it trended in the...
Yes. So if a judge is not...
tech savvy.
Yes, tech savvy.
Or doesn't even have the facility.
So he probably would have been
get away
totally
with it.
misled, yes.
You get away with it. So we need to strengthen the storage. You see, what I sense most judges do is they do it on their own.
They invest in it from their own
personal, and they keep it on their own. But there ought to be a robust system that is central, that is protected, whose integrity is protected, that is centrally administered, so that when you want to retrieve, it's very, very easy. It is important. It will change a lot of things in the way things are done. Many times, there was a time they will say, okay, bring a flash drive. They will ask us to bring flash drive to come and of our briefs, of our documents, of our record. Ask us to bring flash drives. Unfortunately, when you give those flash drives and so on, go and ask them, the ones they brought last year, where are they?
They don't know where it is anymore.
So that area of keeping of records,
yes.
They are retrieving it.
Yes.
Is very, very important. Not just by way of archives for old cases, even for live and live cases. It's very, very important.
Well, I see with the new government that's coming in, I see one of the key things that I've heard them say most of the time is, a private sector driven economy, boosting the economy, building the economy, industrial revolution. But then, courtroom practice impacts not just individuals. It also has a role to play in economic development. In fact, it's central to any economic development. What impact is our current system playing in the development of businesses in Nigeria? And how can we make it play a more strategic and more positive impact that will bring justice sector in tandem with the needs of commerce?
I won't say no. We have a lot of... it's not zero. It's not nil. If you say it's poor, but not very poor, because you still have many cases in the commercial division. There are people for breaches of contracts, enforcement of...
simple case of 100,000
people are still going there.
Can be there for 10 years.
The court system is supporting the economy. However, if you say fair, you are generous. For international commerce, it's almost zero. Because they would rather not use international agreement, they would rather not use your jurisdiction, the laws of Nigeria. They will rather not use your justice system because it's not trusted, because it is slow.
But the local people will use it
They have
because
no
they don't
choice.
have any other choice.
They don't have a choice. And that's why you find them resorting to using the police, using the EFCC
Yeah.
to recover debts, to get people to perform their obligations. They illegally use the police, the EFCC, to recover debts because of the perceived slow pace of justice delivery and not so much confidence in the integrity of some of the judicial officers. However, as I said, more and more cases are being filed till tomorrow, and the commercial division is ever busy. Federal High Court that handles essentially commercial matters, more and more cases are filed. So it is still working, but a lot more needs to be done in terms of the speed with which we dispense with our cases, and also the integrity and quality of our judgments. We need to improve on it. For ADR, people in ADR, arbitration, mediation, you know that once you go to international arbitration, hardly do you find people wanting to use Nigerian law. Everybody wants to go to London. They want to go to Singapore. People want to go because of speed and because of the integrity of your system. So we need to improve. We need to improve the people. And now there's a resurgence of alternative dispute resolution because it is an alternative to the courts in Nigeria.
Would it not be an indictment on the courts?
In a way it is.
Because I see that in the UK,
yes,
people will prefer to use the court system to resolve their disputes than to use arbitration sometimes because they find arbitration more expensive. But in Nigeria, people will prefer alternative dispute resolution than litigation. And that's
you are right and you are wrong. It's not cheap to do litigation in the UK. In fact, before you take your case to court, you have to mind the costs. And that's one thing we need to look at in our judicial system. People who approach the courts should be ready to pay the costs. We see it more as a social service, essentially as a social service in Nigeria. So the filing fees are small. It is more or less funded by government. But while it is true, the cost of the other lawyer, the cost of the other litigant, you should be ready to bear it. So unless you begin to get people to pay, frivolous cases will continue to be filed. But by the time people begin to pay proper costs, you see, before you go to arbitration, you know when you lose, you are going to pay the cost of the other side. You assess your case very, very well. Because you know that when you lose, you not only pay, you also pay the cost of the lawyers, and it will be heavy. So we need to begin to think along that line, even for the court system, so that frivolous cases, and when you go unnecessary adjournments, due to lack of preparedness, if a case is going to be adjourned and you have to pay for the cost of that day, of the other lawyer, of the witnesses, of the court, you will think twice before you seek an adjournment. Once dates are fixed for a case to be done out there, the case are fixed. Hardly do they change. They fix 3 days. We want to spend the next 7 days for the trial. And you see, they don't adjourn cases. Now, once for trials, okay, you adjourn trial now, but now you continue in 2 months, or you continue. Examination of evidence of one person sometimes could take 2 years in Nigeria. That's not how it should be done. It's not even helpful for the judge. It's not even helpful for the judge. It's not even helpful for the witness. Nor is it helpful even for the lawyers.
And not even for the system.
Assemble the witnesses. Once you say it's trial, 1 week, 5 days. Gather your witnesses. That's the way to go. So that you get litigants serious, you get lawyers serious, and the judges too must be ready to do their work. Lawyers, I will say, lawyers pay penalty for late filing. Lawyers pay costs for adjournments, even though it could be more. Judges don't have to. If judgment is not ready, the matter has been reserved for judgment. It gives you a date for ruling, and it's not ready. You give an adjournment. So sometimes judges will ask you to come and readopt because judgment is not ready. They ask you to come and re-argue. They don't get. We all should be ready to sit up. Lawyers in particular should be ready to sit up if you are going to change our perception.
Yeah.
Lawyers will be ready to do the work, and litigants need to know that things are changing. If you want to go to court, it's a lot of money. So if you have avenues that government has provided, Lagos State, for instance, Citizens Mediation Center, Office of the Public, courthouse, they should take them more and more serious. Otherwise, if you have to go to court, be ready to pay for going to court. Yeah.
Right. So, sir, I know you had your background with legendary G.O.K. Ajayi, one of the best legal minds that Nigeria has ever
produced.
Africa has ever produced. From your experience, my viewers would like to know at least two of your notable cases. In a layman's language, I would like you to relate to us. Because people feel that advocacy is a very boring practice, but then we want to know what exactly has been the experience. So just wanted to share with us two lovable landmark cases that you have been opportuned to do, and tell us some of the challenges that you encountered, and then what exactly was the impact on the body of jurisprudence in Nigeria.
Well, if you're talking about cases, you started with Chief Ajayi and then you went into two cases that I have done. I know one of the major issues that has crept into the body of our jurisprudence is the how to execute court processes by legal practitioners. It has crept into our legal jurisprudence quietly, maybe in the last 15 years, or if you like, 15, 16 years. And it has changed. It has affected a lot of this. I have been opportuned to be involved in two major cases in that line, on that issue. I've participated at the Supreme Court twice. If you like, Supreme Court has taken its decision. I am bound by it, but I do not share their views. I was involved in the case of SLB Consortium versus NNPC and First Bank and Mayweather. In fact, in First Bank and Mayweather, they constituted a 7-man panel to review all the cases. I was invited as an amicus curiae, and then we had the opportunity to go through it. The Supreme Court has firmly said that you cannot, if you sign a process, your name must be there, not the name of your law firm. The name of your law firm can be in addition to your name. I have looked at it. The Supreme Court has taken its decision. The matter appears firmly settled by the Supreme Court. That's how to go. That if you sign on top of the name of your law firm, that the process, you have not successfully invoked the jurisdiction of the court, and the process should be struck out. The case should be struck out. You have not. I do not share the view of the Supreme Court. I've had opportunity to persuade them twice. Unfortunately, they ruled against me. But I've been able to contribute severally to the body of jurisprudence along that line. Somehow I feel that I sincerely hope they will take a second look at it in future. For me now, people have learned. People aren't going to be making those mistakes again, apart from the mistakes that had been made in the past. But for me, it's more important to look at it from the underlying philosophy, not the outcome. They have identified a problem, and they have said this is how to solve it. But my own reaction to all of this is, if you say the era of technical justice has gone, many times the Superior Court will say that don't push technical justice, let's deal with substantial justice. For me, that decision, conclusion by this one promotes technical justice. And we also talk about justice according to law. Justice, due process, justice according to law. I think we need to begin to have conversation about law according to justice. As against justice law according to justice. Law according to justice is the one that will make the man on the streets identify with and support and enjoy the product of your decisions.
The outcome, yes.
They will find it difficult many times if you insist on justice according to law. So if you say, because justice according to law deals more with the process by which you have arrived. But law according to justice is more concerned with the ultimate conclusion.
Conclusion, yes.
That after all said and done, have you done what is right? I think we need to begin to examine and re-examine our jurisprudence along that line. So, for me, the position is more of the technicality. They say it's substantive law because that's what the Legal Practitioners Act says and so on. Like I said, I remain bound by the decision of the Supreme Court. All of us are complying with it, but I do not share their views. And I look forward to an opportunity in future for them to reconsider their position.
Outside law, what else do you enjoy doing? What else gives you passion and fulfillment?
By vocation or in terms of hobby?
Hobby.
Yes. I'm an ardent Chelsea
fan. All blues.
Yes, I'm an ardent Chelsea fan. I like to read a lot. I like to follow international news. In those days of the Time magazine, things have changed. Everything now is on your phone or your laptop. Reading international news magazines. I like to watch football and follow world affairs. That's
you see, a lot of people believe that lawyers are boring. And you have just told me now that you didn't tell me about parties, didn't tell me about, but you like to watch football and read a lot of books. Lawyers read, so it's still
incidentally, I find it easy to keep myself company. I could be in there the next one. You can predict me. Office, home, church, office, home, church. I can be on my own for 2 weeks and I'm not bored. I have one thing to read at any point in time or the other. And I'm happy.
And peace, yes.
I'm happy.
Yeah.
I'm happy. When I need breaks, maybe watch football. I'm happy. People want to go do a lot of outdoors. Fine. But reading, current affairs, reading law books, we have to read law books, watch a bit of football. I'm fine.
What's that piece of advice that you have for the young lawyers?
Oh, yes.
Who look up to you. They want to be like you, but they do not understand how your journey through law has been.
I think they should not be in a hurry. Some patience is very important. We talked about it before. Try and do apprenticeship. Make up your mind. That's very important. You need to be focused in making up your mind how you want to practice law. I chose to be a litigation lawyer very early. And I remain focused. We don't all have to do litigation. Within 3-4 years, make up your mind how you want to practice law and stay focused through thick on thin. Don't pick this one today, drop it, pick another one tomorrow, drop it. Remain focused. At the end of the day, you become renowned, you get competency, you get more and more competent in that field, and you will build your goodwill. They should not be in a hurry to make money. Money will come if you are hardworking and you need to build a good name. The Bible says a good name is better to be chosen and great riches. The good name will bring riches for you. Integrity will bring riches for you. Don't be in a hurry. Don't cut corners. Don't rush. That name will ultimately bring clients. It will bring briefs, and it will bring you satisfaction.
Wealth. Yeah.
And wealth. It will bring you satisfaction.
Thank you very much, our viewers. It's been a very interesting session today. And as my learned senior advocate, as Adewale Adeshoko SN has said, law, just according to law, oftentimes work substantial justice against the litigants. But just law, according to justice, is more positive and will develop the society better. Thank you so much. It's been an interesting session with you today.
Thank you very much.
Thank you for coming around.
Thank you. Yes. It's nice to be here. Yes. You are doing a wonderful. Over the years, we find that the spheres of legal practice continues to widen. People are bringing innovations, areas that have been uncharted. Ideas are coming in terms of legal education, law reporting, new frontiers of law. People are doing sports law, entertainment law. Now we have AI, and you have come with this new initiative, and it's a very, very positive contribution to legal practice. It's nice to be here. Thank you.